Welcome to this presentation on British nationality. My name is Reg Bamford and it's my role to introduce Philip Gamble to you. But before I do so, I'd like to cover off on what we'll be talking about, as well as giving a very brief introduction to the rules and the laws governing British nationality. I'm going to introduce Philip to you, but before I do that, I'm going to cover off on what we consider to be definite claims to British nationality. I'm also going to cover off on those circumstances where we feel that people have no claim to British nationality. And then I'm going to introduce Philip to you, and he's going to talk about the main laws of British nationality and how you might qualify. He's also going to cover off on UK immigration, and then I'll finish off at the end, give you an idea of how to find out whether you have a claim. We'll use three classifications, similar to a set of traffic lights. So red are circumstances where we feel you have no claim. Amber, where you are perhaps unsure of your claim and further research has to be done. Or green, where we feel you have a claim. So let's move on to circumstances where we feel that you have an automatic claim to British nationality. And they are: if you were born in the UK before the 1st of January 1983, if you have a parent, and it could be a mother or father, born in the UK before the 1st of January 1983, and finally if you have a parent, and again this could be a mother or father, naturalised in the UK before your birth. In such circumstances we feel that you have a claim to British nationality. Now moving on to circumstances where we feel that you have no claim to British nationality. Quite simply, if you are third generation, in other words, you were born, both your parents were born, and all four of your grandparents were born in the same country, or you hold the same nationality, then it's very unlikely that you have a claim to British nationality. So now we move on to the amber section, and circumstances where you feel you have a possible claim, or you are unsure. They are as follows. Your country of birth is different to that of a parent or a grandparent. You're a woman, or you are married to a British citizen. You have a British parent or a British grandparent. You or a parent was registered at a British consulate in the past. You or a parent spent at least 2 years in the UK in the past. I'm now going to talk about some of Britain's former territories. Here are some of the former British territories or areas where the British in the past had a degree of influence that affected British nationality. This is not an exhaustive list. The full list is much longer than this, but this just gives you a flavour for the wide range of countries where the British did have influence in the past. So this brings us to the crux of the presentation. Most of you will be in that amber column in the middle where you are unsure about your claim to British nationality, but you are struggling to find out the information. And it's our role to move you either into the right column, the red column, where you have no claim, or to the left column, the green column, where we can advise you that you do have a claim to British nationality. And that now brings me on to introducing Philip Gamble to you. Philip is a former Home Office executive, where he worked in their Nationality Directorate. He's the founder and managing partner of Philip Gamble and Partners. He has over 22 years' experience in the subject of British nationality law, and he is widely regarded as the world's leading authority on British nationality. So it gives me great pleasure to introduce Philip Gamble.
Thank you for the introduction, Reg. My name is Philip Gamble, and I've been practicing UK nationality law for the last 22 years. When I started my career, I thought one could only become British through being born in the UK or being descended from someone in the UK. I soon found out that this wasn't the case, as the UK had an influence in many territories worldwide with its former empire, and that British nationality rights can be derived from birth and descent from those countries too. My job is to look at family trees, but I'm not a genealogist. The slide that we're looking at now represents a typical family line that I may look at with a view to establishing a right to UK nationality for the client based at the bottom here. We have our client born in Swaziland, we have a father born in Northern Rhodesia, and we have a great-grandfather born in Fiji. I use this example because it shows quite clearly that there's no direct link with the UK and simply links with other territories overseas that were once under UK influence or control. This is what I call a status trace. I look at the law in force at the time when certain key dates take place, the birth of specific generations, or maybe even the marriage of parents or the marriage of grandparents. When we look at the law in force at the time, we see what nationality status is granted to the ancestor concerned, and we then look to see how that's passed by descent to the next generation. Where there are overseas territories involved, we also have to look at the Independence Day arrangements for those territories and to see if whatever British colonial status is granted at the time can be carried forward to the next generation and indeed in the post-independence era. In this example, we know that the client concerned is a British overseas citizen, and because of the dual nationality restrictions in the countries concerned, we also know that that client or that applicant can upgrade his British overseas citizenship to full British nationality through a separate application. In this seminar, we're to discuss different aspects of the law, including British citizenship, gender discrimination in the previous law, residents in the UK, those born in the UK, those born overseas to a UK parent, the effect of marriage in UK nationality law, the effect of a UK-born grandparent. We will also talk about the old Federation of Rhodesia and Nyasaland and some exceptions, anomalies and loopholes that I found over the course of my career, which I hope you find interesting. Now, throughout this presentation, you'll hear reference to two phrases, one being British by descent and one being British otherwise than by descent. We use these terms to determine whether any given parent can pass British nationality to a child born overseas. Those that are British by descent generally can't pass that nationality to a further generation born overseas, and those that are British otherwise than by descent generally can. Now, there's been much gender discrimination in UK nationality law in the past, and we're going to spend a few minutes talking about the effects of that in the modern day. Up until the 1st of January 1983, it wasn't possible to pass UK nationality law from mother to child born overseas, only from father to child born overseas. On the 1st of January 1983, our British Nationality Act 1981 comes into force, and with this comes equality. From that point onwards, any child born overseas can derive citizenship from his mother or his father. So women now have the same rights in the modern day. It's a common misconception to believe that your mother needs to be born in the UK for you to make a UK or claim to UK nationality. This is not the case. It might be that your mother had acquired British nationality through birth in a UK territory overseas. So birth in the UK is not always necessary for such claims. From the 1st of January 1983, a mother born in the UK can pass the status to the children born overseas. This is always the case. Now, in the lead up to the change in the law in 1983, an announcement was made in the UK Parliament on the 7th of February 1979, confirming that the change would be made and equality would be there. From the point when the Home Secretary, Mervyn Rees, announced this change in Parliament, the UK Home Office started to accept applications for British nationality for those that were born to UK mothers, some 4 years in advance of the law being changed. Those that were registered under the early provision in the 4-year lead up to the change in the law have a specific feature in that they can also pass their British nationality down to their children born overseas. This is an anomaly because it should be fairly obvious that if a claim to UK nationality is being made by descent from a UK-born mother, that nationality is already passed to that applicant by descent in the first generation, and it shouldn't necessarily follow that the next generation should also benefit. However, those who were registered by virtue of being born to a British mother between February 1979 and January 1983 have this specific feature where they can. It was obviously not the intention to create this effect. It's an anomaly within the law. So, mother born in the UK before 1983, children registered by virtue of the advanced change on gender discrimination between 1979 and 1983, the next generation can claim UK citizenship by descent. This is our first example of how British nationality can be passed from grandparent to child, rather than simply in the first generation from parent to child. Now, some of you may be already in the UK and working your way through to UK citizenship based on residence in the UK. Perhaps you're here as a work permit holder or holding a visa issued because you have UK-born grandparents. Generally speaking, a status called indefinite leave to remain, the UK's version of permanent residence, can be acquired after 5 years residence in the UK. Those that hold UK permanent residence, having been here for that period, can generally also acquire nationality through residence, and we call this process naturalisation. An individual naturalising, as we mentioned, has to spend 5 years in the UK. If that individual is perhaps better connected to the UK by virtue of being married to a British citizen, the residential period is cut to 3 years for such applicants. In all cases, whether for individuals or for married persons, absences from the UK are strictly limited to 90 days a year in the qualifying period. So this is British nationality through residence. So, in terms of our acquisition rules, we're going to look at various aspects with this presentation through birth, descent, residence, and a number of others. Residence is our first category. For those born in the UK, if the birth takes place before the 1st of January 1983, very few exceptions aside, that person will be British. If a child is born in the UK after the 1st of January 1983, the child will not always be British. And in fact, the parents have to hold a specific status at the time of that person's birth for the child to acquire UK nationality. In most countries in the world now, this is indeed the case. Birth in a country does not always lead to the nationality of that country, and only usually where the parent holds a residential status at the time of the child's birth can the child acquire UK nationality now. Where applicants acquire citizenship by birth in the UK, whatever the circumstances, we can be certain that that person is British otherwise than by descent, so the descendants of that person will also acquire UK nationality if born outside of the UK now. Now, we've had our discussion earlier regarding whether you're British by descent or British otherwise than by descent. A child born outside the UK after 1983 will acquire UK nationality if the parent is British otherwise than by descent, not if the parent is British by descent. There are exceptions to these rules, and we'll deal with a few of them in the next few slides. Now, we've mentioned that usually a child born outside of the UK, whose parent is British by descent, can't pass that nationality to a further generation born overseas. Now we have some exceptions. In those circumstances, if the parent concerned has lived in the UK for a period of at least 2.5 years, going on to 3 years at some stage in the past before the child is born, it is possible to acquire British nationality for that child by formal application. Applications of this nature have to be made before the child becomes 18 years of age. Up until February 2010, applications were only possible within the first 12 months of the child's birth. It's not impossible that there will be cases out there where parents have tried to acquire UK citizenship for their children just after the 12-month time limit that was originally there, whose cases at the time were declined, who can now have those cases reopened in the manner of reacquiring now that the regulation states that the application can take place right up until the 18th birthday. For cases like this, the grandparent concerned has to be classified as British otherwise than by descent, and generally that would be a grandparent of the child being born in the UK. So, to recap, where there's a UK-born grandparent, where the parent of the subject child is born overseas, and where the child concerned is under the age of 18 at the time of application, and the parent has spent some time in the UK in the past, there are possible claims and applications which can be made to make that child British. That represents our second example of how children born overseas can claim UK nationality in the second generation by descent, i.e. from a grandparent born in the UK to grandchild born overseas. Now, we have our second example of how a child born to parents who are British by descent already can pass nationality down to a further generation born overseas. We talked about the fact that if the parent concerned had spent 3 years in the UK in the past, and where the grandparent of the child was British born, that the child could make it, or an application could be made for the child before its 18th birthday. Where the child is born in a country where nationality at birth is not automatically conferred, the 3-year rule for the parent falls away. So no residential period in the past for the parents becomes necessary. Now, many countries in the world do not grant citizenship at birth, as we said earlier on in this presentation, including the UK, where the parent isn't actually settled at the time of birth. So, a typical example of this might be a husband and wife living overseas. Child is born to them. They choose a country where nationality is not conferred at birth. This might be Zimbabwe, it might be Swaziland, it might be a number of other countries in the world. But where the child does not pick up the nationality of the country where the child's born, British nationality will pass a further generation by descent. So British citizens overseas who have children overseas can acquire UK nationality for the child concerned where the country of birth does not confer British nationality automatically. It therefore follows that the choice of country of birth for your child can determine whether the child becomes British or not, and it doesn't follow that that country necessarily has to be the UK. To recap over our provisions for children and nationality by descent, 2 categories. If the child is not yet born, if the parent has spent 3 years in the UK in the past and is a British citizen by descent, a claim can be possible before the 18th birthday. Or where the child is born in a country where no nationality is conferred at birth, equally a claim before the child's 18th birthday would also be possible. In both cases, the child's grandparent needs to be born in the UK. For those British citizens by descent who've had children born overseas already, an option also remains for that family to come back to the UK, to spend 3 years in the UK now, and then again an application for UK nationality before the child's 18th birthday would be possible. Now, earlier in our presentation, we mentioned that women were disadvantaged in the old law through gender discrimination. There were certain situations in the past where women are actually better off under the previous legislation, and particularly when rights are acquired through marriage. A woman who was a Commonwealth citizen in the past and married a UK man, a British man, before 1949, would acquire the nationality of that man automatically and by operation of law. The man concerned might not necessarily have been born in the UK. He could be descended from someone from the UK, or he could have acquired his British nationality through birth in a former British colony. Where women acquire citizenship in this manner, it's possible to establish rights for the next generation born to that woman. So a woman married to a British man before 1949 may well be able to pass rights down to children born overseas after that date. So we've had acquisition of UK citizenship through residence, through birth, through descent, and now we're looking at British nationality through marriage. With this slide, we have an example of this. The mother is married to the British father before 1949. She's a Commonwealth citizen. She could be South African, she could be Canadian, could be Australian, or indeed any of the other Commonwealth countries. And the man's father was born in the UK. The children of that person, that mother I should say, born after 1949, will be able to establish a right to UK nationality through formal application. So we have again our third example of how British nationality can be passed in the second generation by descent to those born overseas. We have a grandparent born in the UK, and we have a child born after 1949 who can acquire UK citizenship again through formal application. The next question we have to ask ourselves is what happens if that woman divorces, or if the husband dies? Are the rights kept or are they lost? Common sense would decree that they should be lost. However, the law decrees otherwise, and in fact these rights are kept. So, we could have a situation where a woman has acquired British nationality through marriage in the pre-1949 period. She's divorced, she's married a second husband, and oddly, the descendants of the second marriage can also acquire UK nationality in the same way that we described with the previous slide. So here we have our example. The mother is a Commonwealth citizen. She marries husband 1, acquires UK nationality before 1949 directly through the marriage. She divorces, or the spouse dies. She remarries. Children of the second marriage can also acquire UK nationality in the same way as children of the first marriage, even though the children concerned are no bloodline descendant of the person through which the claim is derived, i.e. the first husband. Now, that covers marriages up until the 1st of January 1949. After the 1949 period, and up until 1983, a separate provision comes into force, and it allows women to acquire status from British men in this later period. The status acquired is called the Right of Abode. The Right of Abode is what I would describe as being the next best thing to being a British citizen. It allows complete freedom of entry to the UK. It even allows those holding the Right of Abode to come down the European Community Channel and not queue up with foreign nationals when they arrive at a UK airport. So the Right of Abode is a very, very useful status to hold, and it's given to women who are married to British men in the period 1st of January 1949 to the 1st of January 1983. Again, the man concerned might not be necessarily born in the UK himself. He might be descended from someone born in the UK, enabling his own citizenship to have been acquired by descent, and that still passes to the woman in the same way. I should also add that the right of abode can never be lost unless the woman concerned loses her Commonwealth citizenship, which is quite rare. Now, again, the question arises, what happens if a woman married to a British man in that 1949 to 1983 period divorces or the spouse dies? We're also in a position, as with the previous law, that those rights are never lost. They stay with the woman through a divorce or other termination of the marriage itself. Now, so we've talked about those that are married to British men before 1949, those that are married in the 1949 to 1983 period. If we bring things up to the modern day, the UK still allows the spouses of UK nationals to come into the UK, but rather than giving a direct status by operation of law, now those married to British citizens have to apply for visas to come to the UK and to settle over here. The visas are given in 2 lots of 2.5 years, leading up to a 5-year total, and those applying have to show that they won't be a burden on the UK state by showing what we term as a financial requirement, made up of either income or savings from the people concerned. One must have the intention to settle in the UK if this visa is taken up. Now, unlike the old rights that were given by operation of law, those that are married to British citizens overseas now will find that in the event that the British spouse passes away, that those rights will be lost. Unlike the previous provisions where the rights were actually simply given by operation of law and stayed with the person for life. We therefore have a situation where if migration to the UK is sought by those that are married to UK citizens, and we find that the British spouse is either old or perhaps ill, there might be a question as to how soon that visa is applied for. Perhaps those that are married to those who are ill or infirm may wish to apply for the visa sooner rather than later, and specifically because the rights given to the spouse of a UK national living overseas in the modern day are converted to permanent residency in the event that the spouse dies. So we mentioned that a 5-year status is given for those married to UK citizens. In the event that the British spouse dies during the continuance of that 5-year period, the visa can be converted to indefinite leave, the permanent status during that period. So that covers citizenship through marriage and covers our 4th category of acquisition of British nationality. Our 5th category is Crown Service. By Crown Service, broadly speaking, we mean working for the UK government in some way, shape or form, either in the modern day or in the past. Those that were in Crown Service in the past had the ability to naturalise as British citizens in the same way as those living in the UK. So it represented a way in which persons working overseas for the UK government could acquire British nationality without ever stepping foot in the UK. So we can treat it as a naturalisation category, if you like. We also have to look at what the effects of Crown Service are in the past and in a potential applicant's family tree. A good example of this is listed on this slide, where if we take a child born outside of the UK after the 1st of January 1983, if that person's father or mother was born perhaps in the Second World War years, where the grandparent was serving for the UK government, the UK Army or the military at the time, then that applicant child could potentially have a right to claim UK nationality now. So Crown Service can also have the effect of allowing a child to acquire UK nationality again in the 2nd generation by descent from a grandparent born in the UK. The provisions for those born before 1983 are very much the same. However, it has to be the parents of the child who's serving at the time for a claim to become effective, rather than perhaps a grandparent for those born after 1983. That, of course, makes perfect sense in line with the dates of the Second World War in the 1940s. It's more likely now that the grandparent will be serving rather than the parents who may have served for those born in the pre-1983 period. We talked a little about birth in British territories with the first slides and at the beginning of this presentation. There were many different types of British territory overseas, and as we mentioned before, it's quite possible to derive UK nationality from birth and descent in these places now. We have UK protectorates, we have protected states, we have trust territories, mandated territories, we have full colonies, and even places in foreign countries where the UK exercised jurisdiction over British subjects in those areas. These places can be quite obscure and are not perhaps places one would automatically think of being under British influence. China's on that list, for example, as is Argentina. Now, what is the effect of birth in these territories? Now, we've given many different examples where it's possible for a grandparent born in the UK to pass nationality to a grandchild born overseas, i.e. 2 generations born overseas. Where the middle generation is born in territories such as colonies or protectorates, then it's quite possible that that nationality can pass to the grandchild. We have some examples here. We have the grandparent born in the UK, we have a parent born in a British territory, and the children or grandchildren being born in the 1949 to 1983 period. Generally speaking, this will always give rise to a claim to UK nationality. A good example of this may be if we take the example of a person born in South Africa in, let's say, 1965. The parent concerned is born in China, a place which one would normally associate no connection with the UK. The grandparent, the father's father, on this occasion is born in the UK. Under such circumstances, the person concerned born in South Africa will be British automatically, by virtue of the fact that the father is born in a place where the UK exercises extraterritorial jurisdiction over British subjects at that particular point. And so the effect of birth in a British territory for a middle generation can lead to the grandchild also acquiring UK nationality whilst born overseas. We're now going to talk about how acquisition can take place from a connection with the Federation of Rhodesia and Nyasaland. The Federation of Rhodesia and Nyasaland existed in the 1950s and ultimately was dissolved on the 31st of December 1963. It formed from Malawi, Zambia and Zimbabwe, collectively known at the time as Southern Rhodesia, Northern Rhodesia and Nyasaland. This territory was listed as an independent Commonwealth country for British nationality purposes, and so at first sight we'd think that no connection or no ability to acquire a UK passport would be possible through the territory itself. However, on independence of the territories concerned, which followed dissolution of the Federation in December 63, certain specific features of UK nationality law take effect. A South African, for example, who went to work in the Federation of Rhodesia and Nyasaland would register as a federal citizen while there. On dissolution of the Federation, that person will acquire UK citizenship by operation of law, provided that he or she does not acquire citizenship of Southern Rhodesia at the time. This was due to the fact that the territories of Malawi and Zambia were heading towards independence at that point, whereas Southern Rhodesia was not. And so the UK, if you like, is taking responsibility for federal citizens in that area where they don't otherwise acquire nationality of the only other independent Commonwealth country there at the time being Southern Rhodesia. So it's quite obvious to see that a person who actually has no connection with the UK at all could have gone to the Federation and worked, registered as a federal citizen, acquired federal citizenship, and later acquired British nationality by not becoming a Southern Rhodesian on dissolution of the Federation. If this is the case, an automatic grant of citizenship of the UK and colonies is made in 1963, and when coupled with either 5 years' work in the UK, or perhaps a UK-born grandparent, or indeed if the subject's a woman married to a British man, this leads to full British citizenship being granted by operation of law in the post-1983 period. British citizenship that was acquired through dissolution of the Federation is granted otherwise than by descent, so normally passes to another generation by the same token. Now, so far we've simply talked about British nationality. We're now just going to spend a few moments to talk about Irish nationality. The Irish are a little more generous than the British in terms of their nationality laws, and in fact any applicant or potential applicant who has a parent or a grandparent born in either the Republic of Ireland or Northern Ireland will have a right to claim Irish nationality and therefore an EU passport. It's a very simple concept with Irish nationality law in that it can pass down generations by descent on an indefinite basis, providing registrations are taken place before the birth of the next generation. So, for example, a person who has become an Irish citizen now because of a Irish-born grandparent can acquire the Irish citizenship, and that will pass to their children born overseas as well, therefore passing to great-grandchildren, and in fact that can continue indefinitely. We would term that as an indefinite transmission of nationality. Now, a couple of other points that we want to talk about in terms of whether potential rights for UK nationality may or may not exist. The first thing I should say about adoption, top of our list here, is that British nationality rights are not usually acquired through adoption unless the adoption took place in the UK itself. So it's not possible to look to adoptive parents to make UK nationality claims. We can only usually look at the natural parents of any given child when assessing claims. Some of you may have been included in your parents' British passports in years gone by. This can be a good indicator that a claim may exist to UK nationality now, and would again give a pointer that perhaps some further research is necessary on your family line. Some of you may have what we term as colonial registrations that have taken place. There were large movements of peoples between different territories in the British Empire. A South African who moved to the Kenya colony before 1963 may have registered as a citizen of the UK and colonies there. An old certificate might exist in the family papers, and this again would give rise to the question, well, perhaps some further research is necessary on my family line to see if I can make a claim to British nationality now. Some of you may have been registered or had your births registered at British High Commissions or British consulates overseas. All of these things would give rise to us wondering whether claims would exist in your family line. Equally, in British nationality law, where a previous application has been rejected incorrectly or been treated as abandoned in the past, it's quite possible to have that application reopened again and completed in the modern day. So where application papers are available for a rejected application, let's say in the 1980s, and we can see clearly that that decision at the time was incorrect, it's quite possible to have that case reopened now, even though it might be some 20 or 30 years after the initial application date and decision. So always a good idea to keep papers when they relate to UK nationality. Now, we also have in the UK 6 different types of UK nationality. So far we've only talked about British citizenship, which is the mainline European citizenship used in the UK now. We have 5 other forms: British national overseas, British overseas territories citizen, British subject status, British protection, and British overseas citizen. A British national overseas is a person connected to the old Crown colony of Hong Kong. A British overseas territories citizen is a person who's connected with an existing UK territory now. An example of this might be St Helena or Montserrat. British subject status relates to a person who was connected to British India before 1947 or the Irish Republic before 1949. This tends to be the rarest form of UK nationality that we see today, predominantly because it's extinguished if the subject concerned has the nationality of another country, regardless of which country that may be. A British protected person is a person who was connected to a former UK protectorate or protected state. This form of UK nationality can be acquired by descent in the male line, and it is sometimes extinguished if the subject takes the nationality of another country. Not always. A British overseas citizen is a person who was connected to a place which remained a full UK colony in the post-1949 period. Examples of this may be Kenya, Fiji, Hong Kong, and a number of other places. This particular form of UK nationality is never extinguished if the holder takes the nationality of another country. Now, we're just going to diversify for just a moment and talk about UK immigration as well. The present UK government has made a pledge to reduce the numbers of non-European migration into the UK to below 100,000 persons per year. As a consequence of this, a number of the old visa categories that we used to have sadly been scrapped, limiting the amount of people who can come to the UK in quite a substantial way. We should say that the target has not yet been met, so we do expect further cuts to be made and further tightening of the UK immigration system to limit numbers coming through. The 2-year working holiday visa has been scrapped. This used to apply to all Commonwealth countries and now only applies in a format called Tier 5 with countries where reciprocal agreements exist with the UK. We also had a form of UK immigration which would allow bright young graduates with good earning capacity to come to the UK. This was called the Highly Skilled Migrants Programme, or Tier 1 General. This was also scrapped in April 2011 in its final form. We further had a visa which allowed those that have educated themselves in the UK and acquired a UK degree to stay and work in the UK for a 2-year period. Again, the last year has seen this visa removed. And finally, in July 2012, we find that the ability for a family based in the UK to call over elderly parents to live with them has also been so severely restricted as to make it be as good as scrapped. On a more positive note, we still have the UK Ancestry Visa, and we also have business and investor visas for the UK. The UK Ancestry Visa applies to all Commonwealth citizens without exception who have any one of their 4 grandparents born in the UK. On this occasion, adoption can be used, so a natural or adoptive grandparent can be used. A step-parent, however, could not. Anyone wishing to apply under this category must be over 17 years of age, and they must intend to come to the UK to work here. Those that spend out a 5-year period with this particular visa class can also acquire citizenship through residence, which, as we said earlier, was termed as naturalization in the UK. Again, this is one of the remaining categories. We don't know how much longer this one will remain in force for. But we should say that those that have been granted the visa cannot have it taken away from them if a later change in the law removes the category from the statute books. Those that have acquired the status are given a 5-year visa, and extensions to that 5-year visa for those holding the status again can be granted at the moment on an indefinite basis. So, those that have UK grandparents and come from Commonwealth countries can still come to the UK to live and work. The UK has 2 different categories for those wishing to invest money in the UK. The first we term as a business visa. This generally requires an investment of at least £200,000 into a UK company, whether that company is a new formation or a going concern, it makes no difference. And where that person making the investment can show that they've increased net employment in the UK through that company by 2 persons, indefinite leave can be granted at the end of a 5-year period. So those that want to come to the UK to invest in business here or start a new business here can acquire indefinite leave after a 5-year period, provided that that particular enterprise has given rise to employment of additional 2 UK citizens. For those that don't wish to work, a further investment category is available, and an investment of £1 million into UK government bonds or the active trading stock of UK companies can acquire a visa again for a 5-year period based simply on the money being invested. Investment in property is prohibited, and again, indefinite leave can be granted after 5 years residence in the UK. Those with this visa class, unlike all the others, apart from the business visa, are permitted to spend up to 6 months of the year away in their 5-year qualifying period for indefinite leave. This is substantially different from those on ancestry visas and work permits, who are very, very restricted on the amount of time that they can spend outside of the UK in the same period. Many of the application types that we've been talking about require old documents, and sometimes these documents may be lost. Where we have a lost birth certificate, you can use the website address listed here, providing the birth took place in England and Wales, to find duplicate copies. A similar organisation exists with the General Registrars in Scotland. For those that are overseas, the Department of Home Affairs of the country concerned will have to be consulted with a view to picking up duplicate documents. Now, the standard of evidence required in a UK nationality case is called the Balance of Probabilities. If we were talking about a UK criminal case, the standard of evidence required to secure a prosecution and conviction would be what we term as being beyond reasonable doubt. It therefore follows that the standard of evidence required for proving a nationality case is somewhat lower. Where documents are missing and can't be replaced, other and alternative evidence can sometimes be used. However, a specific certificate from the Home Office is required before passport claims can be put forward on that basis. Affidavits could be a possibility as an alternative for a document showing an event, such as a marriage perhaps. A baptism certificate might be a good alternative for a birth certificate, and the last will and testament may well again show an event such as a marriage, where the spouse is named as the beneficiary in that specific will. So if documents are missing, it doesn't necessarily mean that there is no claim for you. It simply means that other processes will have to be undertaken first before a passport application can be made. When an application is made to the UK government, it has to be made to the correct authority. It always has to be accompanied by the correct fee. A form is not always necessary, but a signed statement is necessary from the applicant showing that details are true and correct. And of course, the evidence is always required with every claim that goes through. In straightforward cases, the Home Office in the UK provide application forms. Where the application, however, is complex and sometimes involves nationality by descent from UK colonies in the first, second, third and sometimes even fourth generation, then a specific submission would normally have to be made to the Home Office to explain why we feel that the application exists and why it should indeed be successful. With such submissions, we put forward the relevant nationality law, showing the authority for what we say to be correct. In summary, you've probably seen that UK nationality is not as straightforward as just being born in the UK. Where you have old British passports describing parents or grandparents as British subjects or British protected persons, or where there's an ancestor born in the UK or coming from a country that's under some sort of UK influence at the time, where there's been Crown service, where there's variation in the places of birth for you and your ancestors, then it's not impossible that rights to UK nationality may exist, and the family line, in my opinion, with any of those features would be worthwhile examining further.
Thank you for that presentation, Philip. If you've followed everything that Philip has talked about, or more importantly, if you've understood it, you're now in a position to determine whether you have a claim or you don't have a claim. Most of you, however, probably still find yourself in this amber zone because there's some further complexity to your family history. In such cases, you could perhaps do your own research, you could contact your British Embassy, or you could incur some fees and ask an expert for their advice. If you still find yourself in this position, Philip and I have come up with 3 easy steps for you to find out whether you have your claim or not. The first is to go onto the whatpassport.com website and undertake a free British nationality assessment. This should take no longer than 2 or 3 minutes to complete, and Philip asks about 20 questions about you, your parents and your grandparents, where they were born and when they were born, and you'll get one of 2 answers once you complete this assessment. This will indicate whether you have no claim to British nationality, or it will list one or several potential claims that you might have. So if you still find yourself within this amber zone and you have some British nationality claims, the second step that Philip suggests you do is to complete a British passport review. This is where you're going to ask Philip to assess your personal and family details. It's all done online, again on that same website, whatpassport.com, and Philip will give you an answer to the question, what is your probability of you becoming British? And he'll give one of 3 answers to you. If Philip feels it's unlikely that you have a claim, or he thinks it's possible that you have a claim, or he thinks it's likely that you have a claim. And this is a guide for you to make up your mind as to your next steps that you want to take. The reason why we've put this step in place is because often Philip will get an email with several attachments to it. Those attachments might be old British passports or birth and death and marriage certificates, with a little simple question at the end of it, Philip, please tell me whether I'm British or not. And as you can imagine, there's so much complexity behind this subject that it takes Philip a long time to give a definitive and detailed answer. So we've put this second step in place called the British Passport Review. So it's a low cost step. We only charge £30 for this particular service, and it gives you an indication of whether you should pursue your claim further. If you still find yourself in that amber zone, you're still unsure, even after listening to this full presentation, but you still want to get an answer for yourself or perhaps a sibling or your partner or a parent, children, even grandchildren, and you're still not sure, then I'm afraid you're going to have to go and do some further research and incur some experts' fees. Now, Philip and his colleagues do offer this service. It's called a status trace. He charges £240 for the service. This UK status trace takes the form of a multi-page report. It is written by Philip and his team of British nationality advisors. It will cover not just yourself, but your partner, perhaps some siblings, your children, even grandchildren, and you'll get a final answer in your quest of finding out whether you're British or not. There are 3 outcomes to the UK status trace. Philip and his team will perhaps identify that you have no British nationality claim, or you or a family member does have a claim to British nationality, or you or some family members have a right to a UK immigration visa, and he will specify what those are and how you qualify for all of them. So let's do a quick recap. Do you have a claim to British nationality? By now you should be clearer as to whether you have one or you don't. If you're still unsure, we have suggested that you do that free British nationality assessment on the whatpassport.com website. After you complete that, you will either be told that you have no claim or there are some potential claims available to you. We then suggest that you undertake the British Passport Review, and this will either kick you out into that red column, confirm that you have a UK nationality claim, or again indicate that you have a possible claim and further research has to be done. If you find yourself in that situation where you still don't have a definitive answer, we offer our UK status trace, where you will be given a final answer for you and your family members as to your valid claim. Just a quick word on the services that Philip and his team do. He's based here in central London, and we can act on your behalf if you know that you have a valid claim and you want us to act on your behalf in completing that application for you. The fees for that sort of service do vary based on the complexity of the case or how much time is involved in preparing it. In situations where you are still unsure about your claim to British nationality, Philip's British nationality team can undertake that UK status trace. They charge £240 for that service. Alternatively, if you feel a bit more comfortable getting Philip to do that status trace himself, he charges £420 for that service. And the final situation is if you or your partner are British by descent and living overseas and you want to pass Britishness to your children, then it's advisable that you get some expert advice as to how one does that. And if you are looking to perhaps give birth in a country that doesn't give nationality at birth, then we do offer that service. It's for £750 and you'll get a definitive answer as to which countries you can move to in order to give birth. And I'll leave you with a final thought as we close this presentation. If you want great tax advice, don't ask the taxman. If you want great British nationality advice, ask an expert.